end the truce after Friday's mutiny. Attorney General K.K. Venugopal says all is well with Indian judiciary. Sources say Chief Justice met all judges this morning before getting on with the day's business. Bar Council of India also claims that the matter has been laid to rest after a meeting with the Chief Justice.
Israeli edge for Indian agriculture, science and technology and security as the visiting Israeli Prime Minister Benjamin Netanyahu and Prime Minister Modi look to strengthen bilateral ties. Modi says Israelis' defense firms should take full advantage of India's liberalized FDI norms, even as the visiting dignitary calls Modi a revolutionary leader.
Army Chief General Bipin Rawat puts Pakistan on notice over cross-border terrorism. Speaking on the occasion of the Army Day, General Rawat warns Islamabad not to test the patience of the Indian Armed Forces or face a fitting reply. The warning comes on a day when the Indian Army gunned down 7 Pakistani soldiers along the line of control.
Come July, you will be able to authenticate your Aadhaar through facial recognition. Amidst growing concerns over data leak, the Unique Identification Authority adds another security layer to Aadhaar. Sources tell ET now that the new feature will help those facing difficulties in using fingerprint or iris for Aadhaar authentication.
Mega ET Now exclusive parliamentary panel on transport and tourism rejects Trinamool MP Derek O'Brien's draft report on Air India sales. Sources tell us that the panel has decided to junk the report due to differences among members. Move comes even as the government decides to split the national carrier into 4 entities before the sale.
Gold imports surged by over 70%, causing a lot of concern. This fuels imports to rise by over 21% and trade deficit widens to over $14.8 billion. Will the government now move to curb the insatiable urge for storing gold in India?
In its last meet ahead of Budget 2018, GST Council likely to tweak compliance for small and medium companies. ET now learns reverse charge mechanism rules might also be eased. Some relief likely for electric vehicles. That's a big ET Now exclusive.
Good evening. This is the India Development Debate right here on ET Now. I'm Supriya Srinath and with me is my colleague Sandeep Gurumurthy. Straight on to the big debate that we are looking at this evening. Something is certainly rotten in the Indian judicial system. There is no doubt that the charges leveled by the 4 senior Supreme Court judges against the Chief Justice are serious in nature and should be examined. Also, the jury is still out on whether the act by the rebel judges is justified, but there are many issues that need urgent attention of lawmakers. But it is important to use this crisis as a trigger to usher in the much-needed judicial reforms and to ensure that the stench is quelled forever. After all, this is the one institution whose credibility and respectability hinge purely on people's faith.
First and foremost is the acute shortage of judges across higher courts of the country, with the government and the judiciary blaming each other for the sorry state of affairs. Posting of judges in higher courts is another grey area, and so far the judiciary has managed to successfully defend the highly opaque Collegium system. The third and the most important issue is the listing of cases, which simply put means who will hear what case. So where to start is the much touted Judicial Commission, the panacea for all ills of the legal system. Is there a need to define the CJI's powers? More importantly, how to ensure speedy justice, measures to restore the glory and credibility of the Indian judiciary. That's our topic of discussion tonight on the India Development Debate. And frankly, we couldn't have put together a better panel than what we have on the show this evening. Nalin Kohli, eminent lawyer and of course national spokesperson of the BJP. From the Congress, we're joined by a legal representative as well, Ami Ben Yagnik, joining us from Gujarat. We've got Prashant Bhushan, lawyer, activist and politician. KTS Tulsi, former Additional Solicitor General of India. R. Jagannathan, the non-legal perspective really, editorial director of Swaraj magazine. And Vikas Singh, president of the Supreme Court Bar Association and former Additional Solicitor General of India. Gentlemen, this is of course a non-political debate that we're aiming to do right here at ET Now on the India Development Debate. Vikas Singh, I have to start with you because there was a chai pe charcha at the Supreme Court this morning. The Bar Council chairman, after meeting, of course, said that kahani khatam ho gaya. After such an unprecedented all-out attack on the CJI, can it really be business as usual?
Well, it was actually business as usual for the judiciary today, and Probably some wisdom has prevailed upon them that this was not the way to have done it in the first place, and accordingly the Attorney General also felt that the way judges were working normal work today with no kind of ill feeling, and also I believe they had tea also together in the morning. So they all assembled for tea in the morning before going to respective courts. So in the tea also there was complete congeniality. So that way also it is assumed that things have sort of settled down.
Okay, that's the word from the Bar Association President. But Mr. Prashant Bhushan, can it all go back to being normal? Can it all go back to being business? Because, you know, the lordships meant and decided to bury the hatchet today. I mean, that's really the big question. After such an unprecedented all-out attack, can it be business as usual? And what needs to be done to restore faith back in the judiciary?
Well, I don't think it is as simple as Mr. Vikas Singh or the Attorney General seem to be making out to be. You see, the 4 judges raised a very serious issue about what I call bench fixing by the Chief Justice, or rather abuse of his administrative power as master of the roster to assign politically sensitive cases to particular hand-picked judges or benches headed by hand-picked judges who are junior in line, etc. Now, so the issue that they raised has to be settled by putting in place rules about how the Chief Justice can go about allocating work to benches, how can he make benches, etc. Those rules must be rational, fair and transparent. Besides, you see, they raised a particular issue about the matter of this Judge Loya, which had suddenly been sent to court number 10 to a judge who is known for his proximity to the BJP, which is certainly a great, very politically sensitive case involving the BJP president, etc. So, that case has not yet been shifted out of that court of court 10. It is still showing as likely to be listed tomorrow before the same judge. So, I do not think that this matter could be resolved just in this manner. It has just by having tea together and say that this is a storm in a teacup, as the Attorney General says. This was an unprecedented step taken by 4 very, very sober, seasoned judges. They took this unprecedented step when they saw that things had gone totally out of control, when they wrote a letter 2 months ago, thereafter orally represented to the Chief Justice, thereafter again met him regarding this Judge Loya's matter, and when nothing was being resolved and the Chief Justice was continuing to function in a very arbitrary and high-handed manner insofar as his administrative power was concerned, then this problem took place.
Okay,
Moreover,
fair enough.
You see, there is also a more serious problem.
Prashant Bhushan, if I may just interrupt you, you made an opening remark. Let me get a quick word in from Nalin Kohli. Nalin Kohli, you know, having made these sort of serious charges, can they go back to being business as usual? Prashant Bhushan's calling it bench fixing. Does it appear like all of these were just pressure tactics? Because isn't it imperative that the dissenting judges, having made those serious charges, follow through on the seriousness of the charges, really prove on what basis were those charges levied? Can they just be brushed under the carpet and all of us pretend as if it's back to normalcy at the judiciary?
Well, number one, I have many things to say, and I'm going to try to make it quick and short. First, about the opening remark that there's something rotten, as Supriya was saying in the judiciary. No, I disagree. It's not something rotten with the judiciary, it's something rotten with people outside the judiciary who are trying to politically insinuate and challenge the independence and the credibility of the greatest institution of this land in terms of the Supreme Court, constitutionally and democratically. Number two, that it is fascinating to note that political parties like the Congress, the Left Front, and even a certain element of lawyers, Mr. Prashant Bhushan would be included in that too. Some of them attended a press conference. I didn't know lawyers were journalists and went to press conferences to ask questions of the honorable justices. This is a great institution collectively. And it's great because each one who's a justice there is an institution by himself or herself. What is interesting to note is, now are we going to now develop a new system whereby, say, an advocate like Mr. Prashant Bhushan or a set of other advocates or a political party like the Congress party or the left front will start deciding which bench is going to hear what matter, which case should be heard when and not be heard when, which judge is and cast aspersions on judges. Actually, Mr. Bhushan himself was recently in a case where he may have been hauled up for contempt. Another case he was, I think, fined 25 lakhs, if my memory serves me right. But the question here remains is that this, when I go and stand as an advocate, or Mr. Vikas Singh stands as an advocate, we don't stand before junior or senior judges. We stand before a justice, 2 of them to be precise, or 3 if the bench is larger or even larger. And they dispense justice not on any seniority or juniority. So are you saying that, say, for example, Justice A, B, C, D, E, who may not be among the top 4, when we stand before them, we do not get justice because they are so-called in Mr. Bhushan's transaction not senior enough? That's a serious allegation, not a correct approach. Today's Times of India has an article by Dhananjay Mahapatra, front page, that talks of the so-called 20 cases which are sensitive. 15 were heard by courts like Court 8, Court 10, Court 11. So what was this about? Was this fixation? And to use such an allegation against the Chief Justice of India on the basis of no evidence, but on an agenda, I would say that he's bench fixing, that's a serious allegation. This is the attack on the credibility of the judicial system. This is not an attack from within. This is an attack from outward, which is creating it. Let's come to Justice Loya. Justice Loya's death, his family today is on record, or yesterday were, and reported in the media today. They are saying that there's a set of advocates, I don't know who, and perhaps some NGOs that are pressurizing them for a sort of an independent or a CBI monitoring or whatever, an investigation. The family says we don't see any ill will. Maybe an element in the family is saying so. So now if today, me, you, X, Y, Z on this panel makes an allegation against somebody, has a sort of an insinuation that this is how, so we shall bring the whole system to a stop because ABC had it. Things have to be born on some merit, not on the desires, and certainly not on the political agendas of liking or disliking. And certainly this talking about saying a judge is close to the BJP. So are you saying that judges were close to the Congress, judges were close to the left front, and therefore justice that has been dispensed from 1950 onwards when the Supreme Court came into being in terms of the Constitution, they have all been by some political agenda. I reject it, I counter it, and I think these are words that should not be used.
Mr. Kohli makes a very passionate appeal on let's not have political insinuations. But tell me, when you represent the Congress party here, and do you believe at one level it is a very, very dangerous path that we have chosen to walk down on? The political insinuations, you know, talking about bench fixing, this is perhaps a very dangerous precedent, because at the end of the day, the high and the mighty, the low behold, the lowest person in the scheme of things, we all turn to the courts for justice. And in some sense, political insinuations on affiliations of judges, them being close to a certain political party or not, is perhaps a very dangerous path we've chosen to walk down on.
Well, I think the point is going a little astray when we hear a political party's panelist speaking like this. I understand his passion for such an issue, but the topic today, or the issue today, is here that some of the finest judges, the senior most judges, came out and held a press conference, an unprecedented event. And what they said was that they wrote a letter 2 months back to the Honorable Chief Justice of India. They accepted that he is master of the roster, but they accepted everything that, well, fine, but we have some grievances and everything is not well in the administration of the Honorable Supreme Court of India. That is what they wanted to bring to the notice of the Honorable Chief Justice of India. Despite they trying hard, they couldn't get an appointment. They met him in person, they tried to talk to him, but it fell on, practically the efforts were in vain as per the say of the Honorable Supreme Court judges, and they had to hold a press conference and bring this out before the nation. What they told the nation was that because of this and we are not being heard, this letter was not taken notice of, we have to come before the nation and tell them that 20 years later it should not happen that we had no souls. And I think it's a very important message that was told to the nation. I don't know, they never spoke of bench fixing, they never said that it should not happen this way or that way. I think the other panelist who went on speaking about it, we should not go that far. The only thing they said was that what is happening is not okay and it should have a relook at the whole things. But it did not happen, and we can't say that because everyone had tea and everything, they never said that we will abstain from work. They never said that we want action right now. They just brought it to the nation, before the nation, that this is happening. Well, so people should not blame us after 20 years that, well, you four were the senior most judges, you did not take note of it, you did not tell anything to us. So that is where democracy word was brought in by them, and that is where we are going to discuss. We are not
fair
going
enough.
to discuss why political parties are interested. We never said that as a Congress party, but we definitely, no, let me finish it. But definitely, when we say that Honorable Supreme Court judges have said, we need to look into it. And Justice Lay, I think we should not blame anybody. There are lawyers with a conscience who come there. You cannot talk about NGOs. These lawyers fight for the people who cannot speak. It should have come suo moto from within the judiciary or from all the lawyers that why a sitting judge who is a CBI special judge given security.
Ami-Ben Yagnik.
In what kind of circumstances?
Okay.
So don't bring lawyers and NGOs.
Okay, fair enough. Your point is taken. Ami-Ben Yagnik, I am going to interrupt you. Ami-Ben Yagnik, I'm going to interrupt you because the idea is to not make this a political debate. Much as our intention is to not make this a political debate. That's happened for the last 4 days on a host of channels, including ET Now. We want to take the story forward.
Sure.
I want to come to KTS Tulsi, and I want to ask KTS Tulsi, does this entire controversy, Mr. Tulsi, highlight the crying need to have new mechanisms for accountability of the judiciary? Can we brush that aside? Do you think the dramatic turn of events now sets the stage for big-ticket judicial reforms, or do you believe there is too much of institutional resistance to reforming the judiciary?
Yes, I think it is high time that we take forward the Judicial Accountability Bill, which is lying pending in the Parliament. You see, we cannot obfuscate the issue. Nalin Kohli says that politicians are meddling in it, outsiders are meddling in it. That's not true. Let's look at the truth, the stark reality, and speak the truth. The fact of the matter is, howsoever unpalatable it may be, the Chief Justice of India, the Honorable Chief Justice of India, has lost the trust and confidence of his own Collegium. Except for him, all the others seem to have lost trust in the Chief Justice of India. Now, it's a very serious situation. This kind of a thing never happened. They've lost confidence to the extent that they thought that the matter has to be taken to the people. After all, this is people's court. And it's no use saying this is not about only allocation of cases to various benches. This is not about which matter will go where. This is not about allocations alone. What this case is about trust in the Chief Justice of India.
Fair point.
And after all, you can't wish away the rest of the Collegium. Chief Justice's office is very venerable.
Sure.
And we all need to have respect and confidence and trust in this. But you can't wish away the four senior most judges.
Okay.
And their anguish.
Right.
Which has been placed before the people. Now the question is, what are the real allegations? Do we have any proof of the allegations?
Right.
And
Yes.
I don't think the Chief Justice should be condemned in this manner.
Right.
If we have proof of the allegations, we must
point.
bring
Mr.
them in a
Tulsi,
formal way.
Yeah, Mr. Tulsi,
And
you're
there
actually
should
pointing.
be a formal adjudication. After
Yes.
all, who will adjudicate the
Absolutely.
Chief Justice?
Mr. Tulsi, you're pointing me in a direction
will
where we want to
adjudicate-
take this
adjudicate
debate.
the Chief
We want to
Justice?
talk about some of the allegations that have been made. We want to talk about the specific points. But before I go headlong into this debate and begin discussing specific points that have been raised, whether it's roster and all of that, I want to take a question from Jaggi, and this is more from a layman's perspective. Let's keep the jurists out, let's keep the legalese out. But Jaggi, there seems to be this overall effort from within, outside, sympathizers, opposers of the judiciary to somehow douse the fire, to somehow send this message, you know what, all is well, everything is all right, the storm in the teacup is gone. There is this very, there is this absolute desire to perhaps send the signal out that all is well, the house is in order, we've doused the fire. What do you account this to? Isn't this resistance at some level to reform the judiciary? And that resistance obviously is from within.
Absolutely, Supriya, you have hit the nail on the head. I have never heard of such an open revolt ending all of 24 hours after it started. What it actually means is that the power structure within the Supreme Court and the people outside, the big and senior lawyers who actually influence all critical decisions in the court, they want to retain the old power structure, because otherwise if you don't do that, how can you go forum shopping, how can you preserve your links with specific judges, how can you use corruption allegations against some judges in order to demand all kinds of things. I find the whole thing farcical. I mean, even the 4 judges, let's assume they came out with the best of intentions, but then suddenly they say senior judges must get to be part of this. What is this if not saying that, look, after first saying that all judges are equal, the CJI is the first among equals, suddenly they want to say that senior judges are a bit above the thing. This is something like saying in 1984, that some people are more equal than others. Basically, they think senior judges are more equal. Secondly, there is forum shopping. You saw yesterday some senior lawyers arguing that the Loya case must be heard in the Bombay High Court and not in the Supreme Court. Now, once again, it's actually a form of forum shopping. What else is it? You are trying to say that Bombay High Court is probably more likely to give me what I want than the Supreme Court. So, my point is, if you do not have 2 major reforms coming up, one, an outside party credible, which is appointing judges, and a judicial accountability bill, you are not going to clean up the system. The cleanup is not going to happen from within the system. The system is in bed with all the evils it is trying to paper it over. That is your problem. You cannot solve it from within. And all this 24-hour revolt just to make a point is actually a power struggle within the judiciary. It is not about solving all the problems that the 4 judges raised.
Comment on that, Nalin Kohli, and I understand you don't want to take a position, contradicting the judiciary, but would you agree that the Indian judiciary is impervious to any change within itself? The point that Jaggi is making, would you disagree with him on the merits of the argument made by Jaggi on the India development debate tonight?
See, there are 2 parts to it. First, I must point out that, and I must make this clear, I am also an advocate and I also am a spokesperson of a national party, the BJP. But the BJP hasn't really stepped into this. Is there a BJP leader who came in? It's the Congress. I mean, it's after all, Mr. Rahul Gandhi did a press conference, Prakash Karat, D. Raja. So the politicization has to be stopped, because end of the day, it's not about BJP, Congress, left or anyone else. If there is going to be a politicization or an insinuation on the judiciary, you're going to kill the credibility of it. And that's an institutional issue. That's my first point. Second is, if there is to be so-called reform, I'll use a different word. I'll say if there is to be any further checks and balances for strengthening the institution, and as Jaggi is pointing, what could it be done? It can either be done through the judiciary itself, otherwise it will be interference, or it will have to be through the collective will of the people, which is Parliament. The NJAC was one such mechanism that came in, but then the court finally held against it, except for Justice Chalameshwar, who was the lone dissenting person there in the NJAC judgment. Among that, there is to be a memorandum of procedure. That memorandum of procedure has to be, after all, between the government and this. It's not about a pressure tactic or anything, but it has to be further to what their own judgment itself in the NJAC says, that we need to move ahead. So who are the stakeholders? Others may have a point of view, others may have suggestions, but can others drive that? That is not correct. Because if others, that is you, me, anyone on this panel or any political party, as a political party drives it, are we not in any way compromising the very thing that we are talking of upholding, which is the judicial system, its independence, its credibility, and making it sure that it remains so? So therefore, this contradiction has to be there. Like Jaggi says, is this not a form of forum shopping? That don't hear it at this bench, but hear it at this bench. I have aspersions on this bench, but if it goes on that, I don't have aspersions. So he who says that is forum shopping, or as he gave it even more succinctly, that if you say Bombay High Court should listen to it and not the Honorable Supreme Court, is that not a question mark on the Supreme Court by someone who believes that I will not get the judgment of my choice? So I think it has to be seen in the bigger picture, and when you look at it in the bigger picture, then it's best left. If the judges today decide to have a cup of tea and business as usual, isn't that good news? Or are we supposed to make it a theatre? No, it shouldn't be. There should be more to the story. No, if they have decided to move on in whatever way they decide, that is for the institution to protect itself, and very good.
No,
because end of the day, if the courts function normally, that's exactly what we
Yes.
wanted.
Yeah. Absolutely. I mean, I think we all want, people to bury their hatchet and move on. It's just that such serious allegations were raised, and we are human beings, and we do understand that hatchets don't get buried over a period of 24 hours. But I think you make some very valid points that politicians can't be deciding what needs to be done, but still there is perhaps the need for executive to step in. And Prashant Bhushan, should the executive step in to catalyze reforms that we are referring to in the judiciary? And do you believe such an intervention is going to strengthen or weaken the judicial system?
You see, there are various reforms which are required in the judiciary, wide-ranging reforms that are required, in which both the judiciary and the parliament have to play a very important role. The first reform required is to make the judiciary accessible to the common people, because today the common people can't afford lawyers, without whom they can't even access the system. The second reform is to make the system deliver justice fast, which means to increase the number of courts and to increase the to improve the quality of judges in the courts. The third reform is to improve the method of selecting judges for the judiciary, make it more credible, more rational, more transparent. And the fourth reform is to make the judiciary accountable, because today we have a system. And the fifth issue that the four judges pointed out is the use or abuse of the Chief Justice's administrative power as master of roster. Because let us not fool ourselves, different judges have different ideologies, they have different predilections, they have different affiliations sometimes, and there is also, let us not fool ourselves, there is also corruption in the judiciary. Now, if the Chief Justice, by virtue of his power as master of the roster, can hand pick important cases and assign them to hand picked benches, then if he wants, he can virtually achieve a desired end to a particular case. That makes him virtually in control of the whole court so far as important and sensitive cases are concerned, rather than just a first among equal. Therefore, these judges have pointed out that there needs to be a proper, rational, fair and transparent system of assigning or distributing cases to different benches, etc.
Okay.
But more important than that, this whole issue has highlighted the need of a independent, credible system to examine complaints against judges. For example, the complaints against a Chief Justice, who is going to examine that?
Sure,
The
that's a fair
impeachment
point.
system we know is a fairly cumbersome and politicized system, not a very good solution to this problem. We need to have a proper solution to this problem in place, which has not been put in place.
Okay, fair enough. Let me get a word in from Vikas Singh on the point that you made. Vikas Singh, let's look at the substance of the issue that's been raised. Has the time come for us to review the process of allotment of cases? Look at another manner. Chief Justice, of course, is the master of allotment, but maybe the other day we had Justice Saldana on this debate, who made a case that maybe we should get experts to come in and execute the master roster so that there are no allegations of selective bias. Is it time to bring in some fresh thinking on how these cases are allotted, if that is the bone of contention here, really? Vikas Singh?
I don't think there is any need for that, but what can be done and which is being followed, like for instance in the High Court, that the roster is declared and people should know in advance that these type of cases will go before this particular bench, and that could be a periodic exercise which the Chief Justice of India can do every month or every 3 months, and that will give a lot of certainty to benches and where matters get listed. And it should also provide that once the roster changes, then a judge earlier hearing the matter will have to give up that matter and it should go to the person holding the roster later. So that way there will be rotation also, and that individual fixing of a matter before a judge and continue to remain with him also will be avoided.
Amiben, do you agree with this? Do you agree with the fact that if the power to make rosters and if that function is dissociated from the Chief Justice, that kind of resolves the crisis and also addresses the one big allegation that why are certain cases going to only a few judges? Is there a bias in which forum is the case really going to? Do you believe that that is a solution to the allegation that has been made?
It can be one of these suggestions, but I think currently or for so many years now, the Honorable Chief Justice of India has been the master of roster. There have not been any issues on this kind of thing, and this is an inside kind of a mechanism which is also the part of the administrative work, and I think we should first understand the whole mechanism. The only thing was that a little transparency is necessary, and they can evolve a method where, of course, we cannot compare the work of the Honorable Supreme Court of India with the works that is in the High Courts. We have the roster system in the High Courts, and as suggested by one of the panelists, but I do not know whether it would work for the Supreme Court of India. So the system, I think, is in place. They may make a change here and there, but transparency is required so that these kind of issues do not come before the Honorable other senior judges. I think there has to be a mechanism inside to work out all these issues. But if we talk about, I think I heard somebody speak of forum shopping, but I think the lawyers are accused of forum shopping, and some kind of predictability or uncertainty, this comes in the picture only when all these forum shoppings go on. So I think there also we need a lot of reforms on this side. The two most important reforms we need is access to the system of justice, and one is speedy trials. People are backlogged. You can imagine the number of matters every year the number goes on, and we are unable to come out with any reforms within the judicial system. Get more and more judges. Forget about right now we talk about selection of judges, but we need judges. There are so many vacancies so that at least a common man can get justice.
Okay. It's a fair point you're making, and we will debate some of those issues. But quick word from you, Jaggi. Let's step back a bit. And you alluded to it briefly in your introductory remark, which is, and a lot of this comment has been made on how it needs to come from within. Reform needs to come from within. But will judges who don't seem to have any agreement on day-to-day administrative matter, issues like how do you assign cases? Do you see them agreeing on judicial reform at all? Is the reform going to come from within realistically?
Absolutely not. When there is a power structure and there is a corrupt power structure and there is a hell of a lot of mutual back scratching going on, reform cannot come from within. If it had come from within, the NJAC bill should have been passed, even if some provisions had been struck down. They struck down the entire thing. They basically made a mistake. I mean, they could have said, okay, the law minister should not be part of it. They could have easily said that maybe some other eminent person should be a part of it, maybe nominated by the government. But the law minister, you wanted to stop interference, direct interference from the government, right? But for that, you struck down the entire bill. I mean, this is the most ridiculous self-goal that the judiciary has committed and has proven that it is incapable of reforming itself. The Collegium system, despite weaknesses, we are saying is still going strong. Instead of that, the Collegium has now split. Now we have 4:1 case there where they want to decide by majority vote. So if you let them decide, I mean, the point is no big reform can happen within a group of people having a mutual back-scratching relationship if some external party is not involved. The reform has to come from outside along with some people from the inside, and if those 4 judges are amenable, you can very well create a new system once they retire or do whatever it is, because You can't do it from within. It is not going to happen, and the very fact that the revolt ended in 24 hours demonstrates once again that you are back to the power structure with small arrangements and shifts in the power within the Collegium and outside.
Let's actually get down to addressing substantive issues. And Mr. Kohli, the High Courts have a vacancy of 398 judges. The Supreme Court has a vacancy of 6. Now, should the government not step in is the big question, because why are the courts dragging their feet on appointment of judges? And one of the reasons why justice is being denied in India to a whole host of people who've been waiting for years for justice is the fact that there aren't enough judges.
Well, of course, India requires far many more courts. I think it has to be done in 3 ways to get rid. One is, of course, repealing of old acts, which Modi ji's government is doing. I mean, acts that are not required, I mean, unnecessary laws, they add to the burden. The second part is, of course, the requirement of more courts, fast-track courts, as well as more judges. With regard to the judges, I think we need to bear in mind that initially, and this was about a year and a half ago, when the question of the MOP or the Memorandum of Procedure came up, we need to bear in mind that in the first instance, there were some appointments as per the old MOP because it was pending with the government. Thereafter, when the Memorandum of Procedure was sent back by the government to the court, and it had to be decided by the Honorable the Collegium itself, at that time, there was a hold up because the Collegium had to decide on how to take it further. So therefore, under the new MOP, things were not getting done. There has been some movement, judges have started getting appointed, and I think both, whether it's the government or the judiciary, in this case the Honorable Supreme Court and the Collegium, they are well seized of the matter and they are working towards it. And almost on a regular basis, we are now seeing appointments or knowing that they are in the process. The second part to appointments itself is the availability of a talent pool. About those who may, among the bench, want to move up to from the bar, move up to the bench. That's one set of people, not may sometimes. The second part to it is checking on the antecedents and etc., which is part of the due diligence process in the appointment of judges. So I think, and then there is the third part, which is the promotion from the subordinate courts to the High Court, as the case may be, or from the High Court then thereafter to the Supreme Court. So I think, it's all of it, and there is a, movement towards it. Yes, it can gather more pace, and I'm sure it will.
Vikas Singh, let's not beat around the bush. Simple question. Do you believe there's a case to revisit the NJAC, the National Judicial Appointments Commission? It was seen as a controversial move by the government, but do you believe, in light of the acute shortage of judges and the absolute opaqueness with which judges are appointed in this country, there's a case to revisit that?
Well, not really, because the turf war is decided that the appointment will be done by the Collegium. But within the Collegium, I felt that neither the NJC nor the present Collegium system is really addressing the real core issue, that is of identifying the right names, and for that purpose doing that research. I mean, there would be, supposing a Chief Justice who doesn't hear a criminal, he's never heard criminal matters, and there would be a very fine lawyer on the criminal side. But since the Chief Justice has never seen him appear in his court, so he will say, oh, I don't know this lawyer, I can't recommend his name. That's very unfortunate, because that system is developed so far in such a manner that if a Chief Justice is supposing never hearing company matters and there is a fine lawyer in company matters, then he doesn't get picked up for that reason. So there should be a scientific basis of analyzing all the names, and it should be a system where the Chief Justice should call people and invite them to become judges, rather than people running around the Chief Justice and the other Collegium members for the name to be recommended, because then you will get the best names. And the moment you have good names, the entire reform, half of the reform has already taken place.
No, there is no denying that we've seen some really stellar judges who've passed absolutely path-breaking and, historic judgments. But I agree with you that I think there is a need to attract more judges to the Supreme Court instead of them being chased. But is there a case to revisit the National Judicial Appointments Commission? And what is the Congress party's view on this? Ben?
No, well, we are not into the political aspect of this, but as I would like to pick up from the earlier panelist, I think we need to have some kind of a criteria revisited for the entry point of lawyers from the bar to the judicial system. We cannot continuously every year crib about backlogs, and we every year cannot crib about saying that we need more procedures, we need proper procedures in place to attract young lawyers who are doing extremely well in the bar to come and join the judicial system, because I think from times several years I've been hearing about access to justice, but we are not seeing any reforms in this particular sphere, and we only get numbers. So I think that is where I think we may, I have no point in arguing about NJAC and now what is a state right now, but the fact still remains, as you gave the number, that the present government is neither appointing so many vacancies, not filling up the vacancies, not coming out with names immediately to fill up the vacancies. I think even if that is done, I think there will be a lot more in the system in order to see that the justice is given to the people whom we are talking about, the common people. You see the lower courts, the subordinate courts or the high courts, there is a complete huge backlog and people have hardly any access to the system.
Jaggi, come in on that. Will giving the government more role, I mean NJAC or no NJAC, but will giving the government more power or any role in appointing judges strengthen or weaken judicial independence?
See, it's not about giving the government more power in judicial appointments. It's about having a judicial appointments commission that is not fully controlled only by the judiciary. Nowhere in the world do judges appoint themselves, not in the US, not in the UK, not in anywhere else in the world. What they can have is, let's say a CJI should be able to veto a candidate brought up by the judicial appointment system. So you must have a system that is outside the judiciary but controllable, both substantially vetoable by the Chief Justice or a Collegium, whatever it is, but you cannot have a system that is entirely within the judiciary. No system is capable of looking at its own faults, and if you are going to have that, you are going to have nepotism and corruption, which is what you have seen a lot in the upper judiciary for a long time to come. So I think it should not be subservient only to the CJI or the Collegium. It has to be a body outside. It cannot be a body. It doesn't mean that the government should control it, absolutely not. You need independence, but you cannot have judges appointing themselves. That is not on.
That's not on, and you can't be a judge in your own case is also not on. So that's the other side of that argument. But Vikas Singh, to the larger point of independence, the judiciary should be absolutely independent, and there is just no denying that. There is no debate on that at all. But the judiciary for long has kept itself away from an RTI. The judges are not bound to declare assets like other public servants are now. Should judges begin to disclose assets, and do you believe something like this is going to bring in the much needed transparency in the judicial system?
Absolutely. I don't see why they should not, and if I am not mistaken, as a voluntary exercise they had started doing this in the Supreme Court. I don't know how many of them have actually disclosed, but they should disclose their assets, and it should be available on the RTI. So I don't see that part of the judges information being not available on the public domain. I don't see any reason why that should not be made available in the public domain.
Good to hear that opinion. Let's debate solutions. Nalin Kohli, as an eminent advocate yourself, and given the backlog of cases, do you believe adjournment should be given only under special circumstances and rare cases, and written reasons should be given for any adjournment?
See, that is a debate that's been on for a while, and actually it can be, and there have been genuine cases also that somebody falls ill, there's a death in the family, adjournments do happen. On the other side is the other part of the story, is adjournments for elongating the nature of the case, because justice delayed is also a question of justice denied. So yes, there has to be some kind of looking at this larger question of adjournments, how it has to be defined, how it can be curtailed, so that you get to a substantive, which also brings you to some issues such as, say, the CPC in terms of procedure. That should we look at the plaint being in a certain format so that the statements all come? Because globally, the normal norm is that you take it. Otherwise, any application comes in, anything comes in, it's open to a counter counter, thereafter a rejoinder, an objection, an affidavit to that. It just goes on and on. So therefore, from that, even a procedural looking at it beyond adjournment. Which brings you to a third point, which is in terms of digitalization, which there has been talk about it. There has been attempts. Some courts have digitalized their entire thing, bringing up the records from down rather than waiting for records to come physically from one court to another court. So there are many areas of work. And I think, yes, the time has come that we start looking at it faster, because after all, it's just not about only courts and about judges. It's about making the procedure leaner, making it shorter, trying to cut down on the places where it gets elongated, and that itself is also reform.
I agree with you. The justice delayed is justice denied, and it should not happen for reasons other than, absolutely unavoidable circumstances. Lower judiciary cases go on for 48, 58, 68 years. I mean, those are the cases that you hear about, and those are not aberrations at all. But Vikas Singh, what's your own view on that? Should adjournment be given only under special circumstances, and perhaps a judge needs to give a written reason of why a case is being adjourned? Because we've seen, example after example of how cases have just been adjourned for decades, if not almost half a century there.
Definitely, because if you see even under the Civil Procedure Code, and adjournment can be given on the ground that a lawyer is in another court. But that is always being done by lawyers, and judges are accepting that. If it is made clear that this will not be a ground, then lawyers will not accept so many matters, and they will ensure that they are present in the court in which, provided also they are sure that the judge will take up the matter. Many a times the lawyer is prepared, the judge is not ready to listen to the matter. So it works actually both ways. If you stop this adjournment culture, definitely it will be a huge reform in the judicial determination.
Okay, so we have agreement on one reform. Jaggi, India ranks 164 when it comes to enforcement of contracts. It takes about 1,445 days on average at the trial and judgment stages to enforce contracts in India. What else do you believe can be done to expedite this process?
See, I wanted to come on the judicial delays. See, the Vajpayee government had passed two laws, once in 1999 and once in 2002, to change the code of civil procedure, so that not more than 3 adjournments are given during by a judge, and that summons are issued within 30 days, and that replies have to be filed within 90 days. But the Supreme Court intervened in this in 2005 in a Salem Bar Association case, and said that no, judges can, if they think it is right, contravene this law. So the Supreme Court actually had made delaying things a free for all for any judge. I mean, this is completely rotten. Why did the Supreme Court do this? I mean, they should have made it very clear that only in extraordinary cases this can be done, but now it has become common to keep delays. So I think first of all, the courts should uphold the law that is intended to speed up justice, instead of actually giving lower courts a free for all. The other thing is, I think you need to digitize, you need to have recorded statements, video record statements. People should be able to give depositions from wherever they are. Today is the day of video conferencing, so many things. I mean, everything can be done now by through video conferencing and other things. So if judges are still living in the stone age, then you can't help it. So I think it is time to completely digitize everything, do a lot of things so that judges, and first of all, you also need to reduce the number of vacations judges take. Okay, even school children do not have that many vacations as judicial officers. It is ridiculous. I mean, what you need to do is to have judges taking vacations, not courts taking vacations. So a judge can take a vacation, let him take a 2-month vacation and go wherever he wants. The whole court does not need to shut down in order to give the whole court a vacation. I mean, this is no institution functions like this.
Right.
I think many of these things need to be taken on board, and I hope the courts reform on these fundamentals.
No, I agree on the vacation, but I've been lobbying very hard for ET now to take 2 vacations annually. We haven't gotten to a consensus there just yet. But Ms. Amiben, 67% of litigation is caused by the government in India. You know, the government is a litigant with some party or the other. Is there a need to have clear-cut guidelines for appeals filed by government? I mean, so much of time, energy, effort is wasted by the state to be appealing in courts.
Yes, I think you're absolutely right. The docket explosion, the significant portion is by the government being the litigator, and the multiplicity of the appeals that is also provided in the legal framework, we cannot blame anybody. But I think the government should have a very clear line as to in what kind of cases they should appeal or not. I think they can just go with the petty cases class, just leave it at that and not go further. But you also find service matters, apart from we cannot control the criminal matters, but at least the civil procedure reforms. I think the Law Commission has given a number of reports, and I think even a few of them, if they are implemented or they are just taken to its logical end, I think there will be a lot of control of the docket explosion. And the second important point is that where is the infrastructure? We cannot blame the judges being in the Stone Age. Where is the infrastructure given to them? If you just see the subordinate courts, I think they're cluttered, and you just see the number of cases that come on board of one particular judge and how humanly it is impossible to handle those cases. And that is where all multi-pronged approaches have to be taken immediately by the government. I think there should be infrastructure, there should be proper digitalization. If the pleadings are computerized, I think there would not be an excuse in the adjournment or seeking of adjournment that I do not have papers. I think very small issue, but if they are curbed, I think there will be a complete control, at least of some significant portion of these litigation processes, and we may not have this kind of a huge backlog which is recurring every day and adding to the docket explosion every day.
Nalin, would you sort of, at a more sort of closing comment really, at a more big picture level, would you concede that a lot needs to be done by the government as well? Because when we talk of ease of doing business, this is probably at the heart of ease of doing business. There's nothing more important than this. We spoke about where India stands when it comes to enforcement of contracts, and I concede that the government has taken steps. 1,200 odd laws have been, redundant laws have been scrapped. There have been, rationalization of tribunals has been happened. There's a national justice delivery mission. I concede that the government has taken steps, but would you agree that this is something that needs to be worked on at a war footing, without intervening on the independence of the judiciary? Whatever administrative steps the government can take to ensure that the judicial process is smoother needs to be done. And what, to your mind, are the top 2 or 3 things that can be done by the government?
See, first of all, the government is seized of it. It's working on it. Because if you look at even the question of arbitrations, which itself have added to the backlog and in terms of how much time they take, to make India a center for arbitration, the government is already talking about it, and I think we are moving in that direction. Take the insolvency code. The Insolvency and Bankruptcy Code earlier under, whether it was SICA, the Sikh Industries Act or whatever, you had an issue with regard to, it could go on for a long time. Now under the Insolvency Code is clearly defined, 180 days extended to 270 days. After which you go, an operational creditor can move. Now that's a huge reform in terms of an operational creditor. Even a debtor actually under section 10 of the Insolvency and Bankruptcy Code could actually go ahead and say that, yes, I'd like to file it before the NCLT.
Right. All right. We thought we'd come up with 5 or 6 concrete suggestions in this 1-hour debate. It's incredible. We probably come up with 15. I'm going to go back and make notes on all of that. Thank you so much to this wonderful panel for taking that story forward really tonight on the India Development Debate on what needs to be done to reform the judiciary. Ami-Ben Yagnik, Nalin Kohli, Jaggi, Vikas Singh, and of course Prashant Bhushan and KTS Tulsi as well joined us earlier. Thanks so much for taking the time out and giving us your perspective on tonight's edition. Supriya.
Thank you very much for being with us on the India Development Debate this evening. It's all about finding solutions. Crisis throws up a problem, and I think it's our job as civilized people and as independent and responsible Indians to find solutions to the problems. And I think finding solutions to the judicial rot is one such thing that we've aimed to do on the show tonight. Thank you very, very much for our guests for joining us and viewers for tuning in.